there are some matters which can be very urgent. So you will not even issue a demand letter. So the demand letter works very well when there is a monetary claim. But where in the case, for example, your fundamental rights have been breached, you've been arrested, or someone is interfering with your property, they have come with bulldozers to demolish your property, you don't have time to issue that demand.
But I demand that you remove the bulldozers within the next 14 days.
You will go to court immediately, and you will file you will file your case under certificate of urgency, and that demand issue will not be necessary.
Why is the demand important? Why is it necessary as a part of the process?
As I've said, the demand is important for only two reasons. One is to lay basis for the suit.
Why?
You are outlining your suit. You are saying you owe me this money. So you are laying basis for that suit. And in doing so, you are giving a notice to that party. And because the demand will usually say at the end of it that if you don't reply to this letter or fulfill the terms that I've said, I will file a case in court without further reference to you. So it gives you a notice, adequate notice, if you are a respondent. So it's an important document.
Why? How should one respond to a demand letter?
It depends. It actually depends. If I owe you money, I will, and I don't have any evidence, any defense, I will say, sorry, just give me more time. Please don't sue me. I will respond.
So
and
I
say,
can respond and say,
yeah,
I see that you're actually asking for me to pay you in 14 days.
Yes,
I'm
but I
willing
don't
to
have
pay,
the money.
but I don't. Can we do 140 days?
Yes. You can always reply.
Okay.
If you're admitting liability and say, okay, sorry, my finances are not good. Just give me more time. I will honor this liability. In most of the cases, especially in monetary claims that are very huge, you're supposed to deny the liability. You deny the liability.
And so how do you respond? So you should
You respond by denying the liability. Two, you can just ignore the demand letter without responding. That's an option you have.
Tukutane mbele.
Tukutane mbele kotini, enda kotini, tukutane huko.
Why?
You can also write back, because these are factual matters. You can write back and deny and say, any suit that I don't owe you anything, your claim is misguided, and any suit that you intend to file will be vigorously defended. So you're pushing back on your position.
Even if you are in a position where you do, you are liable.
You see, the question of liability is not for you to determine. The question of liability is not for them to determine. It's for the courts to determine.
Okay.
So sometimes you push back. Yeah.
So, but if you so choose, if you're an honest person, and I mean, this matter that has been brought is actually So we had entered into a deal with you, Peter, and we had agreed that I'm going to pay you 100 million shillings, and you have met your end of the bargain. You have delivered everything. I've even signed receipts, right?
That's a straightforward claim.
And then I have not paid you. You write demanding, and I'm like, okay, yeah, Peter. But we've had this conversation last night at the club. We agreed, so I can actually write back and say, yeah, I know I owe you. I'm not gonna be able to clear it within this time. That is okay. But in a case where I feel, oh, Peter, acha tupelekane.
Yes, there's some persons who are really litigious. Litigious means even where the claim is
genuine,
an open and shut matter, they will still oppose that claim. That is why then the matter will go to court, and the judge will look at judge or magistrate will look at the evidence and then determine that you are liable by issuing a judgment against you. And that's what happens in more than 60-70% of the cases in our courts. Yeah, you will find that the court is then judging that dispute by determining that you are actually liable, something which you denied before. The problem with that is that some people where the claim is not disputed, you need to take legal advice, because there are some matters which you can incur a lot of costs. Like if you delay to pay a liability and then the matter goes to court, you will pay interest at 14% at court rates.
What?
14% of the claim that you owe if you don't pay at the date when that claim arose, you will pay interest at 14%, and you'll also pay costs. So sometimes when you deny a liability, you take that.
You're taking the risk.
You're taking the risk. Especially if my claim is straightforward. I will just file the case in court. You have denied. I will prosecute my claim, adduce evidence, then I get judgment. The judgment which I will get will legally award me 14% interest annually. So there are so many claims, especially claims against government. The claims that you see against government that run in billions of shillings, a large portion of the part of those claims are interest, which is charged at 14% per annum.
Yeah. So let's look at both sides. There's the one who then is making the claim.
Yes.
And then there's the one who's got to answer or in this case, answer or then deny. So what should you do? Let's start on one side, that you do have a case to make against somebody for whatever. So let's use the monetary issue here because it just seems to work.
Yes.
So somebody owes, or an institution owes for work done or a debt or whatever it may be, and this has not been paid. They've promised, they've given dates have passed, it's not happened. What course of action then should you actually take if, and maybe to some point you've understood that, times are difficult, whatever the case may be, but it's just not forthcoming. What should your first port of call be?
My advice always to anyone who is owed money by another person or company, a third party, it is always important to consult a lawyer. It is important to consult a lawyer for very many reasons. One is that you need to anchor that claim as a cause of action to be filed in court. Secondly, there's most of our claims, apart from constitutional claims, if I've been arrested and tortured by the police, that claim is not time barred. But if you owe me money or I've taken your land and then you don't go and sue me within certain timelines, then your claim can be extinguished.
What timelines are we talking about?
So there are very many. There is a law known as the Statute of Limitations, which for example, it says any claim based on contract. Any claim based on contract, you cannot claim it after 6 years. If I lend you money and you don't pay after 6 years, that claim is extinguished.
Okay.
So you, the person who lends the money, cannot then go to court
yes.
and demand this money to be paid.
Yes, if I have defamed you, there are also timelines for filing that suit. Yeah, so that it's important to always consult a lawyer for purposes of assessing whether your claim is legally viable. And secondly, for also preparing your claim. Sometimes you may not afford legal services, so you'll want to push this claim on your own.
Yeah,
you file the case in person. That is also allowed. You don't need a lawyer, even though it is always recommended that you get a lawyer for your claim to be fashioned properly. So that after you've passed that threshold, then you will file your case in court. You will file your case to the court which has jurisdiction. Jurisdiction means the power to determine that case. And remember that the court system is also structured in a certain way, so that you cannot just go to court. There are some matters which you may be required to go to a tribunal. For example, and here let me just be clear that there are 23 tribunals. And I can give just two examples of the tribunals. The Tax Appeals Tribunal. If Kenya Revenue Authority writes to you a demand letter, and then all of a sudden you go to iTax, they have put a credit there of a tax liability, and you dispute it, you don't go to court. You go to the Tax Appeals Tribunal, which has been determined, set up by Parliament to determine this kind of disputes, and they're all under the judiciary. Secondly, if for example you are HIV positive and you are discriminated against in the workplace or someone
disclose your status,
disclose your status, etc., you go to the HIV appeals tribunal, which has been set then to examine that complaint and award you damages. So there are 23 tribunals. There are some matters then which you also don't file at the tribunal, at the tribunals. You can file them straight away at the magistrate's court. So at the magistrate's court, there's a limitation when it comes to jurisdiction. Claims which are more than 20 million, you don't file at the magistrate's court. Those ones you file at the High Court.
The High Court.
Yeah. If, for example, I've lent you 30 million, 40 million, that claim I'll file at the High Court.
Okay.
Because if I go to the magistrate's court, their jurisdiction is limited to hearing claims above 20.
So up to 20 million
up to 20
is the magistrate's
million,
court.
the chief magistrates.
But if it's an employment-related issue,
if it's an employment-related issue,
even if the claim is 100,000 shillings,
yes. The Constitution of Kenya has established the Employment and Labour Relations Courts as a specialized court to hear employment matters, labor-related issues. So if you have a matter there, if, for example, you've worked in a company for 6 years, you've been dismissed without notice, you file your case at the Employment and Labour Relations Court. If you have a land and environment case, if, for example, someone has taken your land, encroached on your land, you can file that case at the magistrate's court, or you can also file it at the Land and Environment Court, depending on the nature of the value of your claim. Yeah, but ordinarily, the High Court is the one which has jurisdiction in nearly all matters except the ones which are reserved for the Land and Environment Court and the Employment and Labour Relations Court. But all the other matters, the magistrate, the High Court has jurisdiction. The law further says, there are some certain jurisdiction which unfortunately has not been invoked in Kenya, even though it is something which is there. For example, if you make someone pregnant, so that person is unmarried, there's a claim for damages.
Sorry?
There's a claim for damages for making a woman pregnant. That's a claim which you file
if
at
the person is not your wife.
No, that's another claim. Another claim is where if you entice a married woman into an adulterous relationship, or a married man, you can also be sued for damages.
By who?
By the husband. Like if I'm the husband, and
by the spouse.
Yes, the spouse. The husband or the wife can sue. But when you sue you sue at the magistrate's court.
So what are you suing? What is the case here? What are you being sued for? For enticing the spouse into an adulterous affair with you?
Yes, there's a cause of action known as enticement into an adulterous relationship.
But what if it was consensual?
Even if it is consensual,
you enticed each other.
The spouse is entitled to sue for damages at the magistrate's court.
Interesting.
The court has jurisdiction.
Right. Yeah. Back to the other one, where this is an unmarried woman, and she falls pregnant by you. Who can sue you? The woman?
Yeah, the woman can sue.
And?
Yeah, it's a claim in damages. The father can also sue.
Claiming what?
Yeah, the father can sue damages. You made my daughter pregnant.
Then now we cannot.
Yeah, without getting into
even if the daughter is an adult of sound mind. The daughter.
Yes. It's unfortunately a claim which is there in law.
So this is a 37-year-old person who has become pregnant. Their father can sue you.
Yes. It's one of those old draconian laws.
For real.
It's a common law. And unfortunately, Parliament still keeps it in our statute books. Just like bigamy.
What's bigamy?
Bigamy is actually where you are married and you marry another person. So you commit a crime. You can be arrested and charged in court by the police, but is it rarely enforced? It's rarely enforced, that legislation. Yeah, so there are many causes of action in our statute books, which, especially in the law of crime, which enforcement is quite a problem.
Peter Wanyama is our guest. He's an advocate of the High Court of Kenya, legal compliance specialist. He's here today on our Justice Thursday conversation, just learning about the law and how to deal with matters. If you have been sued, what do you do? All right? Or if you'd like to sue somebody, how do you go about it? How do you make sure that you win your case? There's something that you've mentioned a number of times here with cost, and we see it all the time.
Yes,
The
yes.
case has been dismissed with cost, or cost shall be shared, or there'll be... What is this cost story?
Yeah, the cost issue usually accrues in litigation. Where there is any litigation, one of the things which the judge must address is who pays costs, the judge or magistrate. So if you have won, if it's a civil case and you have won it, the person who pays costs of your litigation is the other party, the one who has lost the case.
And cost here means what? Court fees?
Yeah, the cost is not court fees. Court fees, but court fees can be part of the cost.
Okay.
Yeah.
So what is the other cost?
Yeah, so that if I have incurred money to file that litigation, to file that suit in court, I'm entitled to tabulate everything that I've incurred, and then the deputy registrar of the court, if it's a high court matter, if it's a magistrate's court matter, the court administrator, they will assess the costs which is due to me having won the case.
Okay, so let's say I took you to court.
Yeah.
Okay. I went through the whole process of, a demand letter. We went to court, and I was demanding 10 million shillings from you.
Yes.
Okay. I came with my lawyer. You went with your lawyer. I lose the case. And then, so I'm not getting the 10 million shillings that I was demanding from you. You win the case.
You still pay costs.
So what is cost? I pay your lawyer?
Yeah, you will pay to the other party. The costs is not due to the lawyer. It's the costs which is due. Is the money which is due to the party that has won the case. So in every instance where a party has won the case, they are usually entitled to costs as well, paid by the party who has lost. So
I just want to get it right. Are we saying that the legal fees of the loser will be paid?
No, legal fees is different. Legal fees
that is different.
Legal fees is different
It's
from
who
costs.
you hire as your lawyer.
And costs, costs is not legal fees.
So what is cost?
Cost is the money that you have actually incurred to hire a lawyer to file the case in court. For example, if you want to file a case in court which is more than 1 million shillings, you will pay 72,000 court filing fees.
Okay.
Every time your lawyer goes in court, there's some money that you're going to pay. Every time when they make an mention, even when they write a letter,
The lawyer.
there's a money which you pay your lawyer.
Right.
So at the end of the day, all that is attributed to
Costs
costs,
of the suit.
which can then be summarized as costs of the suit, and the party that has lost the case then pays costs.
Okay. We looked at what to do on the side whereby you're looking for somebody to sort you out. Now, what happens on the side where you're defending? What should you actually do? Because I think a lot of people are met with fear when you actually receive that first thing, right? And somebody says, I'm going to go to court. I mean, my God, it's the scariest place on earth.
So what happens?
What do you do? What should you do?
Yeah. So what happens is that.
And sorry, Wakili, you have an intent to pay. Maybe circumstances don't allow you
Don't
to.
allow.
What should you do?
So usually what happens is that if you go to the magistrate's court, for example, if you issue a demand, they don't pay. You have given them 21 days. You can even give them another reminder of 14 days. They don't pay. Then you file your case at the magistrate's court, assuming you are claiming 5 or 10 million. You will file it at the magistrate's court. The magistrate's court will issue summons for you to enter appearance. So this summons will be served with you on you by the court, a person called the court possessor, served on you. And then it usually says you're supposed to enter appearance within 15 days. So what most Kenyans do is to ignore the summons. Yet the legal framework has now developed. I can serve you by WhatsApp. Then I take that screenshot as evidence that I've served you. So it's very easy to serve. I can serve you by email. Previously, it was very difficult to serve. The law was very rigid. For example, in 1992, the President Moi could not be served by President Kibaki. So Kibaki went to court and told the court, but I can't reach the President Moi in an election petition. And then the legal framework was a bit it was not flexible.
Yeah.
So the judges agreed and said, no, you have not served. So the case is dismissed. The petition is dismissed. So service is important, but as I said,
nowadays the service
has been liberalized. You can serve by WhatsApp. I can come to your office and you refuse service. I leave the documents on your desk, take a picture and go. So it is important not to ignore court summons whenever you have received summons. Because if you ignore and the other party can demonstrate service, then they will proceed with the case without you. So that if it's a money claim, you'll be embarrassed next time when you see auctioneers or at your door picking your household goods or taking away your car. So it's always important to make an appearance. Make an appearance. If it's a claim that you owe and you need more time, just make the appearance by accepting service, and then having a discussion with the other party. You can have a discussion and say, please give me more time, because the Kenyan legal system is flexible. It allows for parties to negotiate. You can owe me 10 million, but maybe you cannot pay because of certain economic reasons. Maybe your money has been held up somewhere. I can still give you time to pay. And we can settle without getting a judgment and against me and me being ordered to pay you cost. So the legal system is flexible. So the trick is never to ignore court summons. If you ignore, then you can be in very big trouble. Sometimes if you ignore, I can also serve you in the newspaper. Yeah. Service in the newspaper is allowed. I will go to court and get permission.
As long as you published it in the paper.
Yes, I'll tell the magistrate or the judge that I've attempted to look for you. You are very evasive. Please, can you give me an order to serve that person in a newspaper? That's why you will see, if you open every newspaper, usually on a weekday, you will see someone being served through the newspaper. Yeah.
The term "without prejudice," we see it a lot. In some of these, even in the demand letters. What does it mean?
Without prejudice is a legal term, one of those legalese that we put in letters. Without prejudice means that you want to have a conversation with the other party freely, but you don't want that conversation to be used as evidence in court. So you want to have a conversation. I owe you 10 million. Fine. Can I pay you 7 million? I only have 7 million. So you see, that's an admission that you're making. So that free conversation, you make it without prejudice to your rights. So that person cannot use that letter.
They cannot use that letter
as evidence in court, because you are having a free conversation
and
with
the only
intention.
The only thing that upholds that is because you've mentioned it in your conversation. If I say something to you and then I state that it is without prejudice, that means I've now claimed that position just because I've mentioned it.
You must actually put it in writing. You can't have a without prejudice conversation orally. You must put it in writing. Like if you write for me a demand letter saying, Wanyama, I owe you, you owe me 10 million. And then I write to you back and say, please, I will pay this money within 7 days. Can you give me time? And then I don't put without prejudice on that letter. I will have admitted that liability.
Right.
But if I put without prejudice, I am reserving my rights to defend that
You can
claim.
later deny.
Later on I say, but I'm just having a conversation with you with the hope that we can settle it. So I don't want that conversation to be used in a court of law. So we are having a factual conversation about your liability. So I'll put it on a without prejudice basis so that you don't use that communication against me. In a court of law.
Can you come after the fact to state without prejudice? If I have sent you communication, and can I then come back later and say this is all had without prejudice?
No. You will have admitted the liability. And once you admit, maybe as a defendant, as a plaintiff, that is all I needed for you to admit the liability. And then I tell the judge, this person has no defense to my claim. He even admitted the liability. Here is a letter that he wrote to me.
Yeah.
So his defense is just a mere denial. Yeah. Strike out his defense.
Where? Small claims courts.
Yes.
Okay. So these are matters that are what, up to $1 million?
Yes. Small claims court have been established by Parliament. It's part of the subordinate courts. So they have been established by Parliament to hear matters for up to 1 million shillings.
Right.
Anything more than 1 million, you don't file at the small claims court. It's an efficient way of handling matters. In small claims, you don't even need a lawyer. You will go there to the court system. The court, they will give you forms. You will fill up the forms. You will file that claim in court. You will get summons to issue to the opposite party. It's a court which does not the legal framework has been set in such a manner that you don't raise these technicalities.
It's oversimplified.
Yeah, it's the claim is simple. You came to my house, I gave you 250,000 for an emergency. You acknowledge the ability. By signing here, why are you denying it now?
Lipa bwana.
Yeah, Lipa.
You received it, yeah.
Are you expected to follow this process of starting with a demand letter for small claims court?
Yeah, you can always write a demand letter. It's important to write a demand letter in all cases. Yeah, but once the matter is in the pipeline, the small claims system, they are obligated to determine it very quickly, so that you don't go there, then 2 years down the line, the case is still in court now.
Still pushing for 20.
Yeah, that's the magistrate's court now. It happens in the magistrate's court, but in the small claims court, you can play those tricks in the magistrate's court. And this is one of the tricks which people play. You serve me by WhatsApp. I have registered my number as Peter Wanyama. But my ID indicates Peter Manyonge Wanyama. Then you come and play tricks in court and say, this is not the same person.
It's not me.
You served someone else. And then in some instances, you can be served. And then you deny I was never served. I was never served. And then you wait when the judgment has been delivered. Then you come the following day. And then you now say, please, can you set aside this judgment? Because I was never served. That's a trick people play in litigation.
Right.
But in the small claims court,
it must
the room to maneuver.
Once it starts,
the room to maneuver and to play those tricks is not there. Yeah. So if you have a small claims matter, the best way is to just pay it up.
Settle these matters.
Pay it up, and it was the policy rationale of establishing the small claims court. Because you can imagine having a claim for 200,000, then it stays in court for 7 years.
It doesn't make sense.
We see very many cases where, especially when it comes to employment and labor relation matters, right? Yeah. Domestic workers cases.
Yes.
Which, even from the judges of the Employment and Labor Relations Court, they tell us those are very many that come to them. And people just don't know how to handle them. You find, you've been served, yes, via WhatsApp by someone who claims to be a lawyer representing so-and-so that you hired. You didn't even know that this was the person's name. You're wondering, huh? So-and-so, who's that? I didn't know this was the person. How should people handle such cases? Because there are many now.
Yeah, these cases are not different from the other cases. They'll always follow the same pathway. But the cases are on the increase for the reason that it is a sector of the economy which most people have neglected. We look at maids, house helps, and domestic managers as nobodies.
As disposable.
Yet they have rights as employees. The Employment Act protects their rights so that they are entitled to reasonable pay which is not below the minimum wage. They are entitled to all the other benefits which accrue to an employee in a setting. But most of us, unfortunately, in our domestic settings, we don't follow. So when they get terminated, most of them now go to court or they get advice. When they get advice, then you will find that there's a resurgence of these cases. The cases are increasing because the employees, those domestic workers, their rights, they don't have trade unions to protect them. So that's the only way we can protect their rights. So when they come to me, I will look at the case. First of all, verify the identity, and it's important for you as the employer to also verify the identity of the person you're employing. Have an ID. So that you don't say that this person never worked for me. So we will have an identity card. We will verify that he worked for you. We will look at the law. He worked for you for more than 2 years without minimum pay. And then we look at the circumstances under which you terminated. We will deem it unfair. Then we will file a claim for damages, loss of pay, damages, etc. And then the court will assess and award some money. So it's always important to just follow. As the employer, it's important to the employer, in this case, the owner of the house, please just follow the law. Follow the law when it comes to minimum.
What is law, Peter? So does it start from having a contract, a written contract? Is it important to have a written contract with everybody who works for you?
It is preferable to have a written contract. It is preferable to have a written contract, even though the employment relationship can be implied. It can be implied even if you don't have a written contract. It can still be implied. If that person worked for you, not as an independent contractor, because an independent contractor is different from an employee. So if they have worked for you in the circumstances that show that they're actually employees, then you cannot run away from that obligation. The best way as an employer is to have a written contract, even though most of us don't have written contracts with domestic workers. But pay them also reasonably. Let them have all the rights which an employee has, like leave days, remit NHIF payment for them so that they can get a card.
Housing levy.
NSSF and housing levy. It's preferable you do that so that later on you are not found liable.
Do we find, every time we hear lawyers say the law is very clear and et cetera, that the Constitution then is a supreme document through which all of these things that we essentially take to court then are held up against. And I know that maybe it would be difficult to say that courts will act in a certain way over time because cases are different. However, Peter, do we find that when it comes to constitutionality over an issue, or when it comes to the rights of an individual, will those be held up against or above anything else when it comes to these cases? For example, if somebody has brought a case against me, but I did not have an opportunity to defend myself or lay my claim or deny, it can be found that that was unconstitutional, and a judge may then grant me a stay, might be able to grant me reprieve because I didn't have an opportunity to defend myself. Is constitutionality and the rights of an individual upheld over and above anything else, regardless of what the case may be?
Yeah, that's right. The courts apply the rules of natural justice. So that even if you are deemed to be the devil himself or herself, you must always be given an opportunity to be heard. So the question of denial of that opportunity to be heard elevates that matter to the realm of the constitutional rights, such that if you have never served me with pleadings, with the case, all I see is auctioneers coming out there. And it happens in some cases. I'm entitled to go to court and say, but I was never heard. So the moment the court hears that you are never served, and that means you are never heard, then they will set aside the proceedings and start afresh, because the right to be heard is so fundamental in our legal system, such that you must be heard. That is why a litigant, a plaintiff, person who is suing, is required to prove. He must prove that you are served, and he must prove that by filing a document known as an affidavit of service. Sometimes judges go to a very judges and magistrates, they go to a very extra length to give room for the defendant and to give latitude for the defendant. in cases where they have not been served, by demanding that the plaintiff proves that service. That is why for the plaintiff, you must be crystal clear that you actually served. And you'll be required to file an affidavit of service. And where you have not served, then the proceedings will always be set aside, and then you start afresh. Yeah. So service is very, very critical in our legal system. Service of court papers. Very, very important.
It's a big thing.
Yeah, it's very important.
Okay. Many comments coming in here on that particular issue of somebody suing you because they got pregnant.
Yes.
By you. What would they be suing for? So this is not child support.
Yeah. Under our customs, under our customs, if you, for example, you make a lady pregnant and you're not married to that lady, there are some maybe cows that you are entitled to pay.
Yes.
You're supposed to pay.
Yes.
So if you don't pay, that claim is enforceable. You go to the magistrate's court and you sue. You've made someone pregnant. For example, if I am the father of the girl, I'm entitled to sue you. You've made my girl pregnant. You've not married the girl, and our customs allow
for some penalty.
Ordinarily some penalty. So I'll go to court, and the magistrate's court, and sue you for that. If, for example, you have not paid dowry, and our custom, you have stayed with my girl for more than 10 years, you have not paid dowry. Sure. I have made demands for dowry through the normal channels. You have not paid. I'm entitled to go to court, in the magistrate's court, and sue for the dowry that is due to me as the father of the girl. That's a claim which is allowable. Yes.
Peter Wanyama is an advocate of the High Court of Kenya. He's been here on our Justice Thursday conversation. Today we chose, let's just go into the basics of just understanding the basics of law and how to deal with matters in court. Thank you very much, Wakili, for joining us. We'll invite you again soon for more of such conversations.
Thank you.
This is the Situation Room, the only way to start your day.